Hello बच्चों, let's see passage 2. It talks about the Supreme Court on Tuesday expressed its displeasure over Union Minister Amit Shah making public speeches in poll-bound Karnataka about the scrapping of the 4% quota for Muslims, terming them as not appropriate and reminding that sanctity has to be maintained on a matter that is sub judice. A bench headed by Justice K.M. Joseph made the observation that after senior advocate Dushyant Dave, appearing for petitioners challenging the withdrawal of the quota, alleged that Shah's statement amounted to contempt of court proceedings. Why, when matter is sub judice, should such statements be made by anyone? We want to know. Justice B.V. Naragathan, the other judge on the bench, asked. Dave alleged that Shah was making public speeches during election meeting to justify the scrapping of quota, despite the apex court taking cognizance of the validity of the decision. तो यहाँ पे बेसिकली बोला गया है कि जो अमित शाह हैं, जो अभी यूनियन होम मिनिस्टर हैं, उन्होंने एक नॉन अप्रोप्रिएट टर्म यूज किया था जिसमें उन्होंने बोला कि जो 4% ये मिलता है, कोटा मिलता है मुस्लिम्स को, वो स्क्रैप कर दिया जाएगा. तो क्या, तो यहाँ पे जस्टिसेस ने ये क्वेश्चन किया कि क्या ये स्टेटमेंट्स देना एंड ये स्टेटमेंट्स को पब्लिक के सामने बोलना isn't it subjudized to the very core of the constitution. And it also said that कि ऐसे statement about scraping of the quota बोलना when the validity has already been taken into cognizance by the Supreme Court, is it necessary or it is not? So again it is said that if it is true that such statement should not be made by public functionaries when the matter is sub judice before the court. तो जब कोर्ट ने ऑलरेडी उस चीज का कॉग्निजेंस ले लिया है तो पब्लिक फंक्शनरीज को इन मैटर में स्टेटमेंट्स देना इज नॉट ट्रू. The three-judge bench, which also included Justice Hasanuddin Amandullah, said. Let's see further. Solicitor General Tushar Mehta, appearing for the Karnataka government, sought to defend Shah by saying his statements needed to be seen in context. अब जो कर्नाटका गवर्नमेंट के साइड से डिफेंड कर रहे थे शाह को, तुषार मेहता, उन्होंने बोला कि इसका कंटेक्स्ट समझना बहुत इंपॉर्टेंट है कि ये स्टेटमेंट दिया क्यों है. दवे सेड दैट शाह वाज प्राउडली सेइंग दैट दे हैव विड्रॉन द 4% रिजर्वेशन. अब यहाँ पे जो अपोजिट काउंसिल था वो बोल रहे थे कि भाई इसमें कंटेक्स्ट की क्या बात है, जो शाह ने स्टेटमेंट बोले वो बहुत प्राउडली बोल रहे थे. उसके बाद मेहता ने अगेन बोला इफ समवन सेज दैट दे प्रिंसिपली अगेंस्ट रिलीजन बेस्ड रिजर्वेशन इट इज कम्प्लीटली जस्टिफाइड. कि अगर कोई बोल रहा है कि हम रिलीजन बेस्ड रिजर्वेशन नहीं देना चाहते हैं, हम उसके अगेंस्ट है, तो ये बहुत जस्टिफाइड स्टेटमेंट है, ये कोई अनजस्टिफाइड या अनकॉन्स्टिट्यूशनल स्टेटमेंट नहीं है. दवे काउंटेड इट बाय सेइंग आई एम सॉरी टू से इट इज नॉट रिलीजन बेस्ड रिजर्वेशन. मेहता सेड आई डोंट वांट टू डू पॉलिटिक्स हियर. सो बेसिकली टू एंड फ्रो एक्सचेंज ऑफ आर्गुमेंट्स है. जस्टिस नरगतम interjected to say we want discipline to be maintained. Mehta said Dave may move an application supporting his allegations so that it may be known in what context Shah has made the statement. Dave said he would do it by Wednesday. Justice Nagarathan said there should not be statements like this. When Mehta said we do not know what statement is attributed to him, Dave responded by saying Mr. Amit Shah said 4% reservation for Muslims were unconstitutional and BJP had removed it. But Joseph recalled that in 1971 that the then Bengal chief minister was held in contempt for holding a media conference defending a rationing order that was pending before the court. Mehta said a person is also entitled to his fundamental right to freedom and expression. Justice Joseph said we may have reservations about reservations, but we can't let it politicized in this manner. The court adjourned the matter to 25th of July on a request from Mehta. So basically यहाँ पे जो ऑर्डर पास हुआ था 4% ऑफ रिजर्वेशन कोटा ऑफ मुस्लिम को स्क्रेप करने के लिए, उसके लिए कॉग्निजेंस लिया गया था कोर्ट में और ये उसके आर्ग्यूमेंट्स है. लेट्स सी द क्वेश्चंस. क्वेश्चन नंबर 1 says what did Justice Joseph recall to illustrate his point about the politicization of reservations. Let's see the options. A says a case where the CM was held contempt of court for holding a media conference. This is right. This is explicitly being told by Justice Joseph कि when such statement was being given by a chief minister, he was held as contempt of holding the media conference. B says the case where CM was held in contempt for violating the sanctity of the judiciary. He does not tell anything about the violating of the sanctity of the judiciary, so this is a wrong option. C says in case where CM was held in contempt for interfering with the judicial process. उनको जुडिशियल प्रोसेस में इंटरफेरेंस के लिए नहीं कंटेम्प्ट बोला गया था, उन्हें मीडिया कॉन्फ्रेंस रखने के लिए कंटेम्प्ट दिया गया था. सो दिस इज ऑल्सो रॉन्ग ऑप्शन. डी से द केस वेयर सीएम वाज हेल्ड इन कंटेम्प्ट फॉर मेकिंग फॉल्स स्टेटमेंट. यहाँ पे स्टेटमेंट की वैलिडिटी या ट्रूथ ऑफ द स्टेटमेंट को नहीं जज किया गया था, बल्कि स्टेटमेंट देना ही इन इटसेल्फ कंटेम्प्ट माना गया था. सो दिस इज अ रॉन्ग ऑप्शन. D seventh question says what was the Supreme Court's observation regarding Amit Shah's speeches on scraping of 4% of Muslims in poll bound Karnataka. अब इसमें हमें बताना है कि सुप्रीम कोर्ट ने क्या ऑब्जर्वेशन ली थी कि जो अमित शाह ने बोला है 4% कोटा को स्क्रेप करने वाली बात, वो सुप्रीम कोर्ट ने किस व्यू में देखा. ऑप्शन नंबर ए says the Supreme Court appreciated Amit Shah's effort to educate the people about scraping of the quota. No, Supreme Court did not appreciate such statement by Amit Shah. So this is a wrong option. B says the Supreme Court found Amit Shah's speeches to be appropriate and within his fundamental right to free speech and reservation. एक्सप्रेशन, यहाँ पे फंडामेंटल स्पीच राइट टू फ्री स्पीच एंड एक्सप्रेशन की बात ज़रूर की थी तुषार मेहता ने, जो डिफेंड कर रहे थे अमित शाह जी को, बट सुप्रीम कोर्ट ने बहुत एक्सप्लिसिटली ये बोला था जस्टिस ने कि अगर आपकी कोई रिजर्वेशन है रिजर्वेशन के लिए, तो यू शुड कीप इट विद इन योर सेल्फ एंड नॉट मेक सच स्टेटमेंट्स इन अ पोल बाउंड स्टेट. सो दिस इज ऑल्सो अ रॉन्ग ऑप्शन. सी सेज द सुप्रीम कोर्ट एक्सप्रेस्ड इट्स डिस्प्लेजर ओवर Amit Shah's speeches, stating that they were not appropriate and the sanctity has to be maintained on a matter that is subjudice to the कोर्ट. यहाँ पे सब्जुडाइज का मतलब होता है कि कोर्ट ने उस चीज को कॉग्निजेंस ले लिया है ऑलरेडी और कोर्ट ने कुछ डिसाइड नहीं किया है. तो सुप्रीम कोर्ट ने बहुत अप्रोप्रिएटली ये बोला था कि अप्रोप्रिएट नहीं है कि आप बीइंग अ पब्लिक फंक्शनरी आप ये सब स्टेटमेंट दे रहे हैं, इससे सैंक्टिटी ऑफ द कोर्ट मेंटेन नहीं हो रही है. सो दिस ऑप्शन इज करेक्ट. डी सेज द सुप्रीम कोर्ट फाउंड अमित शाह स्पीचेस टू बी इन लाइन विद द ऑनगोइंग लीगल प्रोसीडिंग challenging the withdrawal of the quota, again a wrong option. Let's see question number 8. It says what did Dushyant Dave allege regarding Amit Shah's speeches on the scraping of 4% quota for Muslims. हमें बताना है कि जो अपोजिट काउंसिल थे दुष्यंत दुबे, उन्होंने क्या अलेज किया. Let's see the options. A says Amit Shah's speeches were in line with the ongoing legal proceeding challenging the withdrawal of quota. No, this was not something which Dushyant Dubey alleged Amit Shah of. This is a wrong option. B says Amit Shah's speeches were necessary to defend BJP government's decision to withdraw the quota. This is not also something which Dushyant Dubey alleged Amit Shah of, so this is also wrong option. C says Amit Shah's speeches were amounted to the contempt of court proceedings. This is right option because Dushyant Dubey did state that what statements Amit Shah made were in contempt of the court proceedings. D said Amit Shah's speeches were politically motivated and aimed at gaining vote in the poll-bound Karnataka. Again, a wrong option. Let's see question number 9. How did the Solicitor General Tushar Mehta defend Amit Shah's speeches? हमें डिफेंस काउंसिल ने कैसे डिफेंड किया ये बताना है. Let's see the option. Option number A says Tushar Mehta state that Amit Shah's speeches were in line to educate the public about the withdrawal. No, Tushar Mehta did not give any such statement, so this is a wrong option. B says Tushar Mehta stated that Amit Shah's speeches were in line with the ongoing legal proceeding challenging the withdrawal of the quota. No such statement was made, so again a wrong option. C says Tushar Mehta stated that Amit Shah's statements need to be seen in context. Tushar Mehta ने बार बार ये बोला कि आप इसका context समझिए कि ये किस कॉन्टेक्स्ट में स्टेटमेंट दिया गया है. सो दिस इज अ राइट ऑप्शन. डी सेज तुषार मेहता स्टेटेड अमित शाह स्पीचेस वर पॉलिटिकली मोटिवेटेड एंड एम्ड एट गेनिंग वोटर्स इन द पोल बाउंड कर्नाटका. No, Tushar Mehta did not give any such statement also. So this is also a wrong option. Let's see the last question. What did Justice Joseph recall during the proceedings? Let's see the options. Option number A says the contempt court proceedings against Amit Shah for his speeches in the poll-bound Karnataka. No, Justice Joseph did not recall the contempt proceedings which were for Amit Shah. B says Bengal CM's media conference defending a rationing order that was pending before the court of law and resulting into contempt of court. This is a right option क्योंकि जस्टिस जोसेफ ने ही रिकॉल किया कि बंगाल सीएम जब एक मीडिया कॉन्फ्रेंस उन्होंने ली थी तो उसको कंटेम्प्ट ऑफ कोर्ट माना गया था. C says the ongoing legal proceeding challenging the withdrawal of 4% Muslim quota, again a wrong option. This was not something which was recalled by Justice Joseph. The fundamental right to speech and expression, again a wrong option. I hope the passage was understandable. All the very best.